Hello, my name is Christie Arkovich, and we are a bankruptcy and student loan law firm in Tampa, Florida. And I wanted to cover real quick some issues with private student loans. Basically, I mentioned in a prior video that the Homaidan case is going to start sending out class action notifications to borrowers of formerly Navient, Sallie Mae, loans like that may have been actually discharged in a prior bankruptcy. And so the loans specifically, they need to be, basically the Second Circuit held that for a private educational loan, for a private student loan, to be excluded from bankruptcy, in other words, for it to survive, the attendance must have been at an eligible institution and also must have been funded only with higher education expenses. And so how do you determine that? Each school has a cost of attendance, each Title IV school. And so where you go for that is the website is under 𝗖PEDS. So it's nces.ed.gov and then /ipeds /use the data. I'll go ahead and put a link down in the description below. But basically, it's a little complicated, but you look through, we do have some screenshots that you're welcome to contact our office. If you'd like to get copies of those screenshots, you can see here's what you're looking for, here's how you're doing it. I frankly would want to do that. It's kind of you kind of don't know what to do otherwise. So you're more than welcome to contact our office at info@ChristieArkovich.com. And I'll go ahead and send this to Sandra, our intake coordinator, so she'll know to be able to email this to anyone who asks. But basically, you're using this 𝗖PEDS system to look up the institution, looking up the school by name and so forth. And then the reported data, you'll input where you went to school, what years, and it will basically show your financial aid and different things with respect to the actual cost of attendance. As for an eligible institution, what I do for that is I go to the federal, I just Google this, school code, and I usually will type in the years that someone has went to school. So let's say it's 2009. So federal school code 2009. And you'll see that you've got the Department of Education has a list, and these are by alphabetical order. And you just run down and see if your school was on the list of eligible institutions. If it is not, if your school is not there for the years that you went to school, then that's where your loan may not be an eligible institution, and you may be able to discharge or argue that that loan was in fact discharged in your bankruptcy. We have done this a number of times for probably the biggest area is Caribbean medical schools. There's a lot of them down there. The vast majority of them are not eligible institutions, and therefore we can argue because they're not on this federal code school list for the years of attendance, that loan was in fact dischargeable and was automatically discharged in the prior bankruptcy. So do take a look at that. The eligible school is a big portion of what we do, as well as cost of attendance. And either or is important because it is the creditor's burden to show that this loan is potentially exempt from discharge. If they don't show that, then arguably the loan should be exempt from discharge. We have always been filing adversaries as kind of a comfort order to our client to make sure that, hey, everyone knows this loan was discharged in bankruptcy. And part of the reason that we've done that is because the confirmation order or the subsequent discharge order in a bankruptcy, whether it's Chapter 7 or 13, it doesn't really have a list of what debts are discharged. So we frequently would get a separate order that says, hey, this specific student loan was discharged. If we did not, then our client would usually hear from the servicer later, and they would basically hear something like, no, these loans, the student loans are not dischargeable in bankruptcy. And that's something that's gone on for many, many years. And I'm glad that the Homaidan case has addressed that. It has tried to address that on a national basis, which is very difficult to do with bankruptcy courts. You often have a lack of jurisdiction from one court to another, one state to another. And so I'll be curious to see what the final outcome is of that class action notification opt-in, opt-out process. But do know that you have avenues. You don't have to just pay the debt just because Navient, Sallie Mae, or some servicer on their behalf is saying that you owe it. They may or may not be correct. And so there's a lot of new information about that. Feel free to continue to watch our blog. We've had a bunch of information posted in the past on this. There'll be new information going forward. There'll be additional email or different YouTube videos and things like that. And you can always Google some of these terms too, particularly if you're out of the state of Florida and you want to know, has your state, has your circuit ruled on private loans of your type? And when you look at your contract, you can see what type it is, if it's tuition answer loans, or if it's something else. And trust me, there's probably something that's been written about that in the last few years. So I hope this has been informative to everyone who's looking for cost of attendance and wanting to know what that is. I hope you all have a wonderful day, and thank you. Please subscribe and contact us if you need further assistance. Bye.